Court rise.
Before I proceed further, could I make a discreet inquiry as to for how long this case has been set down? Because now told it was set down for a day, which encourages feelings of great pessimism in me. I can see circumstances in which that could be true, but we'd always assumed it was going to go into a second day at the bar. What is the...
Well, we can go into tomorrow, but we were very much hoping to finish today.
I see, right.
So let's see how we go.
Let's see how
We were first told it was a 2-day case, and then we were very firmly told about a fortnight ago that it was a 1-day case.
No,
Very
we
firmly
can't,
told.
We can't go into tomorrow, I'm sorry.
You can't hear, no. Well, in which case, yes. I mean, we were not, well, all I can say, my lady, is that was not information that come from us, because at the bar we had always assumed we would go into a second day, if not, they would exhaust the entirety of it. But there it is. We'll do the best we can. Indeed, we must. In fact, comply, there's no question. Can I then come to the legislative framework very briefly? This is the authorities bundle at tab 12. This is the Constitution. And again, I'll take this very rapidly.
It's very, very clearly set out in your case.
Yes, it is indeed. Yes, it is indeed. I mean, it's the provisions of section 111 at page 77, which vests the disciplinary control over judicial officers in the Commission, and it's at 1291, which perhaps just requires a moment's consideration, that they may, with the consent of the Prime Minister, by regulation or otherwise, regulate its own procedure, etc. And I'll come back to that if I may. Then if we go to the relevant regulations, these are the regulations that were made pursuant to the provisions of section 1291. There is a slight oddity, but everyone appears to accept that it's an oddity that can be digested with the Chief Magistrate being described as a head of department. He has been so treated, we understand that there's no reason to suggest that that's any error on the part of the courts below familiar with the local terminology. At 84, then, one starts. An officer who is allegedly guilty of misconduct, etc., is liable to disciplinary proceedings. Then 84B1 is the first important one, where the Commission becomes aware of an allegation of misconduct, I will hear in material words, being a head of department, the Commission shall appoint an officer to investigate such allegation. So one sees immediately that it is an particular allegation that has to be investigated. At 90 subsection 3, one sees the obligation to give the officer under investigation written notice, and again only the material words, give an explanation concerning the allegation to the investigating officer. In consequence of receipt of that, at subsection 5, the investigating officer shall furnish the Commission with relevant documents together with his own report on the particular act. And then at 90.6, subparagraph 6, the Commission, after considering the report of the investigating officer and any explanation given under sub-regulation 3, shall decide whether the officer should be charged with an offence, and there's an obligation also to leave the officer with no misapprehension as to the precise nature of the allegation on which the charge is based.
I'm puzzled by this because, I mean, I don't want to spend time on it because it hasn't been raised, but these are the Public Service Commission regulations under the public service part of the Constitution. I'm sure that judicial tenure and judicial and legal service, that's a different commission.
Yes.
Don't they have they have under section 111 power to exercise disciplinary control over persons holding judicial office.
Yes.
And as I've understood it, there's always been a distinction between public service and judicial service. Well, why is this? Why are these proceedings regular if they're under the public service provisions?
Well, they've been apparently just adopted, and in the event he is technically the head of a department.
Well, he's a
Well, I
he's
appreciate-
being. I mean, he's a judicial officer. I think the two are probably exclusive, aren't
Well,
they?
put it this way, my reaction was the same as my lord's when I first saw this, and I asked the question, but I was told, no, this is perfectly regular, this is what's expected to be done. I don't think my learned friend Mr. Knox actually does the commission suggest that it is fundamentally ultra vires or anything of that kind.
Yeah, I mean, but there may be distinctions, and certainly we've had a number of cases in relation to the Judicial and Legal Service Commission from the West Indies, and I've never seen a judicial officer being disciplined under the Public Service Commission part of the Constitution.
Well,
I mean, the case you cite, well, you cited one of them in your case, and that was presumably, I'm perfectly sure, under the Judicial.
yes.
Well, Mr. Belloff,
This is the way in which it's been conducted hitherto, and I'm certainly not instructed to take a point that the entirety of these proceedings have been ultra vires.
Right.
I think we'll have to proceed on the basis that, at the very least, the regulations are in similar form.
yes, well, maybe they are.
Yeah.
So there's the definition of officer. On page 77, I think you've much spoken the idea that it is an officer.
Yeah.
Well, these regulations, I think my Lord Mance, in fact, has properly recollected, indeed my Lord Phillips and Baroness Hale were in the case, the Jurity case, in which the Vice President gave the leading judgment on behalf of the board, and one sees, if you want to go to that, it's the same bundle, at tab 2 at page 9. Now, this is the proper answer. By a notice, some 8 lines in, by a notice published in the Gazette on the 23rd of February, the Judicial and Legal Service Commission adopted the provisions of Chapter 8 of the Public Service Commission regulation which deal with discipline.
I see, so
they
it's
were-
identical.
Therefore, they are identical.
Yeah, well-
And that's the mechanism by which it was done. And we'll have to, again, I think one will assume that that's intra vires as well. And then, finally, then just going back to the recitation of what we say are the material provisions, one sees, perhaps I ought to, particularly because Mr. Knox reposes some importance on this, at 95 is that which actually tells one about the constitution of the tribunal. I won't read it now, but one of my lords asked the question. That's where the answer is to be found. At 98(1)(c), it proceeds at the hearing before the tribunal, and it's indisputable. Before the case against the officer is presented, the officer may submit that the facts alleged in the charge are not such as to constitute the offence with which he is charged, and the disciplinary tribunal shall make a report of the submission to the Commission for its decision. It's against that background that the ultra vires point arises, and my lord and my lady are very familiar with the nature of the factual substratum of that. That is to say that there was a difference between that which was mandated to the investigating officer to investigate, that which the chief magistrate was invited to provide an explanation on, that which fell, therefore, to be considered by the Commission, and that in different form, is in different form to the actual charges. And one does recollect that not only does the charge, as now drafted, differ from the original allegation in terms of omitting any suggestion that there was a refusal to testify, but it's also detached it chronologically from the original allegation which tied it to what was done in the court. By omitting that, it's given, as it were, the flexibility to attach it to that which was done previous to the hearing in the court. And that is a matter actually of some significance, which, in our respectful submission, and it's entirely my fault, it may be that the board are not sufficiently appraised of precisely what happened in the court. Can I just remind you, it is common ground and we don't need to rehearse this again, that early in the morning on the 5th of March, there was a discussion between the Chief Magistrate and the Chief Prosecutor to the effect that the Chief Magistrate was not prepared to give evidence. And we actually say that that's the occasion now which is referred to in the charge. We say that it's not referable to anything that happened, as it were, sotto voce or extraneous to the actual presence of the magistrate in the witness box in the court precincts. Because if one looks at Miss Antoine Brown's statement, more particularly than perhaps I did this morning, can I just show your lordship precisely, my lady, precisely what it is that she actually says about the incident, as it were, in the court. And that's at paragraph 30. If we go back to tab 10, paragraph 35 of her statement in the documents under embargo. I'll just get back to that. And it is, I think, a matter, it may be now, of some greater significance than I previously appreciated. If one looks at paragraph 35, one sees that at 34, she said that Mr. McNicholls entered the courtroom and went into the witness box where he was about to be sworn. Then she refers to the fact that Mr. Peterson told the court, having regard to a position adopted by the witness, was going to adopt a certain course, etc. And then Mr. McNicholls comes out of the witness box. I then indicated to Mr. Peterson, senior counsel, the witness should go into the witness box and state his position. Mr. Peterson spoke to Mr. McNicholls at the prosecutor's table. I did not hear that conversation. Mr. Peterson then indicated to me that Mr. Nichols said this was not necessary. Mr. McNicholls then left the courtroom and the magistrate had discharged the accused. So what appears to have happened is that what happened in the witness box actually preceded rather than succeeded a conversation in the precincts of the court. The only conversation which Miss Brown Antoine deposes to as taking place in the court is after the witness had been called and then the prosecutor had said they were taking a certain course. And all that it appears that Mr. McNicholls, the Chief Magistrate, said on this second occasion is that he didn't want to go on the record and state what his position was. There's no indication in Miss Brown Antoine's statement that he indicated again that he was refusing to testify. And clearly, if by then the prosecution had decided to withdraw the case, there could be no causative link between this second conversation and the abandonment of the proceedings. The proceedings had already been abandoned. And if one wanted to be entirely clear that the Disciplinary Commission or the Judicial Services Commission are now pinning their colours entirely to the earlier conversation on the 5th of March, one only needs to look at the printed case for the respondent at paragraph 7. What is there said on the Commission's behalf is it is respectfully submitted that the respondent was entitled to charge the appellant with misconduct on the basis that he informed Mr. Peterson on senior counsel on the 5th of March that he was not prepared to testify further in the criminal proceedings, and indeed on the basis so informed on the 1st of March as well. We respectfully submit that the parenthesis cannot be correct in the light of a charge which refers only to the 5th of March. And then it goes on, because he admitted all this in his written explanation, the investigating officer, on the 21st of March. Now, I'm not going to take the board back to this, but the admission was an admission as to the conversation early on the 5th of March. There was no admission to, indeed no statement made about any what I'd call extracurricular dialogue in the precincts of the court. so that it's quite clear by now that the charge that is brought entirely focuses on a discussion early in the morning on the 5th of March that the Chief Magistrate was not prepared to testify further. And that, although, as I've said, I would be perfectly content to argue this case on the basis that there might have been a subsequent second statement previous to the magistrate going into the box and previous to him not being afforded the opportunity to give evidence or otherwise. Actually, I don't need to make that concession because on a clearer reading of the evidence, it's clear that it's obvious that it's only the early conversation that day that is now relied upon. And I should just say that when one looks at the transcript, by definition, of course, in a transcript, one isn't told what dialogue there was between persons who weren't actually giving evidence. There's nothing actually inconsistent with the transcript and the sequence of events I've described. So against that background, what we say very simply is this. We say it's contrary to the express procedure set out in the regulations for the Commission to decide to charge an officer with charges which were not the subject of the allegation to be investigated. And we've taken you through the regulations to make it clear it's such allegation, the allegation of misconduct, which is the one to be investigated. It's that allegation which the person investigated is to provide an explanation of. It's the particular act in respect of which the investigating officer makes a report, and that is plainly a reference to the particular act which is the subject of the initial allegation. And then under 96, the basis then is to formulate a charge on the basis of that allegation. And although, of course, 90 subsection 6 says you've got to make precise what the charge is, that's because you may wish to narrow the charge from what was previously contemplated, not that you can enlarge it or make it a different charge from that which was there before. And we say that Mr. Justice Jamadar was right in saying that the surviving charges are different. He was wrong in saying that a sufficient nexus is satisfactory. I repeat what I said in answer, my Lord, in the chair of the President's question. Proximity is insufficient. Identity is what is required. Again, the Commission are on the horns of a dilemma. If they say it's all the same thing, then why do they need to reformulate the charge in the way in which they did? In our submission, the reason that they reformulated it is because they recognised that they could not bring home a charge of refusal to testify in court in circumstances where the particular officer was never given that opportunity for reasons I've already explored at perhaps a tedious length with the board. The next point, at the point on the regulations, again, just looking, one sees if, for example, in the course of an inquiry before the tribunal come to a conclusion that a different charge would be appropriate to that which they are then concerned with. At 105, you see, it shall cause the officer to be informed in writing of any further charges, and the procedure prescribed in these regulations in respect of the original charge shall apply in respect of such charge. So in other words, you have to go back to square one if you are deviating from that which was originally charged. That's for the disciplinary tribunal, but we say similarly that must be so in relation to a decision to prefer charges, simply because the language of the regulations permits no license to, in fact, mutate into a different charge. And we also say that this is actually consistent with fairness, bearing in mind the time constraints under which we are now properly operating. I just draw your attention to the fact that in the Judicial case, which I've just referred to another purpose at paragraph 29, Lord Hope did say, and we quoted this in our printed case, the constitutional right to the protection of the law and the principles of natural justice demand that particular attention must be paid to the need for fairness in the investigation. And fairness means cleaving to the same allegation that the investigation is concerned with and not deviating from it. And we've already made the point that the reasoning of the Court of Appeal saying that the 4 other charges should not go ahead, actually, consistently, the logic of that analysis would be fatal to the 2 charges that remain. It hasn't been alleged that the Commission have any scope to proceed otherwise than in accordance with the regulations. Section 129 allows them to decide upon the appropriate regulations with the Prime Ministerial consent. That's what they've done. The Prime Minister hasn't consented to any derogation. There's no discretion in the regulations to reformulate a charge. There's no anti-technicality clause, as one sometimes finds in disciplinary regulations of various bodies, and the regulations themselves at 84 make it entirely clear that one's liability, and I'm now quoting, to disciplinary proceedings are disciplinary proceedings in accordance with the procedure prescribed by these regulations. So in our submission, the ultra vires point is sufficient itself, and by itself it is fatal to the charges as presently brought. Of course, I accept that it would be open to the Commission at this juncture to start the procedure all over again, treating what is in the present draft of the charges as the initial investigation to be investigated. Were that to be the outcome, may I make it clear on the Chief Magistrate's behalf that there might be arguments as to abuse of process, oppression, delay, etc. But that would be what we say. If those were not available in the particular section on this case, that would be the proper course for a commission where it determines that the original allegation is unsustainable, but some allegation which is a cousin but not a twin of the other could be properly pursued. We've also referred in our printed case to the Panday case, not the same Panday in the Judicial Service Commission at A3.
Just before you leave these regulations,
yes,
could you just help on 103.2b? What's happening here?
This is in the course of a hearing.
Yes.
Yes, where such an officer, included by well, this is a disciplinary hearing. I'm trying to refamiliarize myself with this. This is a single-person disciplinary tribunal, and where he receives a report of findings of a report of the proceedings up to date. I'm sorry, I confess I'm not familiar with this. Can I just read it to myself very quickly? It seems to be concerned with the possibility that the findings could give rise to a more severe penalty that was previously in contemplation. Not necessarily.
I mean, looking at 2b, it does look as one of the options is that the disciplinary hearing continues.
Yes.
And that then, on the basis of the report to the Commission can actually impose the penalty without any opportunity,
Yes.
prior opportunity to the defendant to make any response at all.
One might ask the question whether or not, as it were, the rules of natural justice would not supplement the omissions of the legislature to borrow that.
Safe dismissal. They
Yes.
can't dismiss.
They can't dismiss, I'm told, it's not. It's fully versed in this. Of course, what it can't do, I mean, it's a peculiar process, but it doesn't, I think, touch on the present issue, because if and insofar as one concerned with a change in the nature of the charge, it's 105 that constrains the disciplinary commission tribunal to, as it were, go back down the snake and go up, as it were, the ladder from the start.
Yes.
I'm not certain that I can help.
All right.
All I can say boldly, but subject to contradiction by Mr. Knox, that this isn't going to be a solution to this particular problem. The Panday case, which is a Mauritian case in this particular instance, this was simply a circumstance in which, before exercising any coercive powers or compelling retirement in that instance, the relevant commission was required to call from a full report from the Chief Justice, which the officer could then respond to. The officer wasn't given an opportunity to respond, and you will see in paragraph 18, the board concluded that that failure was sufficient to determine the appeal. And we would simply say mutatis mutandis, although it's not quite as blatant here, nonetheless, the failure to accord to the Chief Magistrate the facility that the regulations accord to him to be called upon to answer the particular allegation equally is fatal to the conclusion that has been reached to proceed with these two charges as presently drawn without reverting back to the start of the process if that were available. So that's really, that's the first point, the ultra vires point, self-contained, sufficient, and in our respectful submission, correct. The second point, an unfairness point, as my Lord the President in the chair indicated, it may be that the strongest point that we should have been given an opportunity to make submissions as to why the charges should not be pursued is the companion to the first submission I've advanced, that is to say, you haven't, the Chief Magistrate has not been given an opportunity to address this particular allegation at any stage, and in fairness, he ought to have the opportunity to do so. It may be said by Mr. Knox, he said, well, what would he have said? Well, one of the points is that we don't actually know necessarily what he would have said, because he hasn't actually been given the opportunity to deal with that particular allegation. One of the matters that he might well be able to say, and would not have been open to him on the assumption that what had happened in court was a refusal, is to say that the facts don't amount to misconduct, as now charged in relation to a conversation early in the day. I say that because were the position to be that he had actually gone into the witness box, been asked the question, refused to answer it, refused to take advice from the Chief Magistrate that he ought to do so, etc. In those circumstances, I find it difficult to suggest that something which would then be a contempt of court, might be a contempt of court, would not amount to misconduct. But, as I say, it's quite different if the charge brought against you is that prior to going into the witness box, several hours before, you have repeated an indication that you don't actually intend to give evidence. And as, again, the Court of Appeal and Mr. Justice Janadar have recognised the formulation in the mandate given to the investigating officer, which was the basis upon which the Chief Magistrate was asked to respond, did divert him from the true nature of what is presently charged, to use a colloquialism. It took his eye necessarily away from the ball, and that's why, of course, the explanation that you see that he has given does concentrate on the fact, well, had I actually been asked and told I had to, I would have. Now, the leading case on this, which the board may well be familiar with, is the Rees and Craig case. We cite it for the general proposition that is no doubt not in dispute, that the mere fact that one has, as undoubtedly the Chief Magistrate would have, the opportunity to raise points of law and fact and discretion and the like in any hearing before the disciplinary tribunal doesn't mean that the general rules of fairness may not be engaged so as to permit him to make representations at an earlier stage. And indeed, Rees and Crane was a case in which the board held that such an opportunity to respond to allegations should have been accorded to the judge in question before representations were made to the president that the question of his removal ought to be investigated at all. So there's no dispute as to the general principle. The question is as to whether or not the general principle is here engaged. Now, the main point, of course, that we make is in relation to the fact that the precise allegation has never been put to him, never been given an opportunity to answer that. But we've also added to that, and your lordships and my lady have the point, that the allegation, that the breaching of the confidentiality which should have closed the proceedings of the investigating officer, and in particular the commission, was breached in a manner which attracted what the Court of Appeal said at paragraph 14. I'll just, if I may, give you the reference, bundle 31287. These developments attracted widespread controversy. There was an avalanche of unrelenting and sustained media coverage, both in the print and electronic media, relating strong expressions, adverse opinion, directed principally against the Chief Magistrate, and to like effect one will see in the judgment of Mr. Justice Jamadar at pages 528 and 532 for any note that the board care to take. That's common ground, and what's also common ground is that the responsibility for this initially was the failure of the Commission to keep their deliberations private. And again, Court of Appeal said, paragraph 60, page 1331, the Commission's procedures were flagrantly ignored or broken, to like effect Mr. Justice Jamadar at first instance at page 526. And of course, the result is that the Chief Magistrate was in what one might call a twilight world. First of all, he has this document, the report of the investigating officer, circulated in the public domain in an unofficial way. And my lord and my lady may recollect that when those who are now acting with me on the 4th of July of 2007 directed a letter to the Commission, we've seen that, it's in supplementary record 2 at 1815 to 1816, asking whether or not the report that had been published was indeed the authentic report, or some of it a bastardized version, or even some curious emanation of an editorial mind, the Commission refused to confirm this. This is at July the 11th at page 1818. And it was only before the Mr. Justice Jamadar, when you may recollect this somewhat odd procedure in which he was asked himself to investigate inter alia the authenticity of the document, as we've said in the statement of agreed fact at page 41. At that stage, the Commission said, yes, that actually is the report. So that were it to be said, the Chief Magistrate actually knew what was said, and he wanted to respond to that, he could have responded. Our response to that is he cannot be under any obligation to respond to a document which he doesn't know is an official.
I don't think that point's being made.
It's not. Well, I hope it's not being made against us. But, I mean, can I then just very briefly, because without prejudice to the point that I make, that We simply don't know, because he's not had the opportunity, precisely how he would respond to that. Just look very, very briefly at the report, because one can see with respect that there are certain arguments that would clearly be available to him. Now, this is, I promised, or were threatened, I'd need to return to this, and I'll do so again, if I may, with all deliberate speed. This is at tab 10 of Appendix A to the tab 10 of the embargoed documents. And it's Appendix D. Appendix D, tab 10, embargoed documents. And I'm only going to necessarily take this selectively, but I mean just to illustrate the point that there were matters that could have been debated. Right. First point, page 2 out of 6. On the information before me, there's absolutely no dispute that the Chief Magistrate refused to be cross-examined in the criminal proceedings held before the presiding magistrate. Not so. It's never been accepted that he refused to be cross-examined, and indeed the Commission appear, it may be, to have recognised that fact and that the allegation is not actually repeated. Indeed, it goes on, next paragraph on the same page, it's difficult to appreciate the Chief Magistrate's statement that he never contemplated criminal proceedings against the Chief Justice. Well, that appears to be, however tactfully expressed, a statement that the Chief Magistrate was not to be believed when he said he thought it anyhow is a matter for the police, but as I say, he's never been given the opportunity to deal with that particular point. Over the page, at page 3, just before is there justification for the Chief Magistrate's decision, there's a conclusory paragraph. It appears the Chief Magistrate's decision not to rely himself on cross-examining criminal proceedings may have compromised the rule of law, administrative justice, decision led to a waste of human financial resources, succeeding in sending the wrong message to the general public, and no opportunity given there now to the Chief Magistrate to say, but actually it's the prosecutor, and this, that, and the other could have happened. Indeed, the explanation that he gave before the Mustel Tribunal. Then there's a really somewhat cruel observation at page 5, second main paragraph. Another of the Chief Magistrate's reasons for refusing to be cross-examined, as stated in his letter of the 13th of February 2007, was his concern about my junior officers being put in a dilemma to adjudicate on a matter concerning my testimony. Then the question asked, did the Chief Magistrate resent the thought of having to appear before one of his subordinates at the criminal proceeding? Well, 2 points. First of all, that's not what the Chief Magistrate's letter says. He's explaining the dilemma for the junior officers, and it's nothing to do with his own resentment of having to appear. And secondly, the allegation of resentment is a serious matter, again, that's never been put to him to respond to. So then one has, and then at the end, last page 6 out of 6, it is indeed mind-boggling to hear the Chief Magistrate state his explanation that if the Chief Director of Public Prosecution Lawyers or the presiding magistrate would have had indicated my reason for not testifying were not accepted, I would have testified. Well, why did he say it's mind-boggling? I mean, maybe that it's a matter that ought to be explored, but on the face of it, in our respectful submission, it is perfectly credible. It's entirely consistent with, firstly, the fact that the Chief Magistrate always said that he'd be prepared certainly to testify in an inquiry and did. Second, he did collaborate to an extent with the prosecution. He gave statements, albeit reluctantly. He appeared in court, albeit reluctantly. There's no reason to assume that in that fraught state of mind, some proper prompting from the magistrate before he was appearing might not have led him to a different course. And again, one may say, well, may be right, may be wrong, but without the opportunity being given to the Chief Magistrate to explain himself and to answer that then in our submission. Again, there is the hallmark, the stamp of unfairness in simply going ahead without ever asking him to make any comment on the report or indeed the charges as finally drafted. In all the circumstances in our submission, it is clearly a position which generates the unusual course which is vindicated by the decision in Rees and Crane. Now, in Rees and Crane, again, bearing in mind the timing, we have actually set out what it was that the board considered to be the circumstances which did engage an obligation on the facts of that case to allow the judge threatened with disciplinary charges to make representations in advance as to why the charges should not be pursued. And we've dealt with that in our printed case at paragraph 34. Again, bearing in mind the time, bearing in mind the board may wish to refresh its memory of Rees and Crane, I can't put the matter any more fully, certainly no better than it is put in the printed case at that juncture. So that's, as it were, the second point. Now the third point, the unsustainability point, again, I'm going to try to keep the matter within relative bound. We've set out at paragraph 49 through to 51 what we say is required to bring home a charge of misconduct. We've also accepted that if one refuses to answer questions in court, that would be a matter constituting a contempt of court. We've excerpted from Arnage, Eady and Smith what is no doubt trite law, which is at bundle A14. I don't need to trouble the board with that. We have, however, and this is a case to which I did refer at an earlier juncture in response to my Lord's question, in particular my Lord Manners, pointed out that in circumstances where a witness does appear unwilling to give evidence, there is a course that ought, in fairness, to be taken with the witness. Can I just ask you to look very briefly at that? This is a decision, it's at tab A8 of our Bundle authorities. This is a criminal case, witness refusing to testify in that particular instance through fear. It was a case of rocks throwing and the like. And one sees at page 5 out of 6, the Court of Appeal constituted by Lord Justice Rhodes, the Federal President of the Family Division, and Madam Justice Smith, who then was. Halfway down the page, finally, though again it's not a consideration which arises in this case, it has been repeatedly made clear, and I do emphasise the adverb repeatedly, that unless there are good reasons for dealing with the matter quickly, the question of sentence, that's for a contempt of court, is best left to be dealt with at the end of the trial, at least the end of the Crown's case. So long as the prosecution case remains open, it's always desirable, it's always, again, I emphasise that, always desirable, the witness should have the chance to reconsider his position with the benefit of legal advice. Where the refusal of the witness to give evidence is maintained, he must nonetheless be given the opportunity to give evidence as to his reasons in the summary proceedings contempt which follow. Such opportunity and or the opportunity to apologise personally or through counsel he's represented are essential to a fair and reasoned decision upon sentence. Now, some of that is immaterial, but what is material is the recognition by the Court of Appeal that witnesses who appear to be guilty of a contempt of court, which would certainly equate to misconduct in the disciplinary context, should be given an opportunity to reconsider. The court there mentioned with the benefit of legal advice. Lord Mustill referred to, in his questioning of the Chief Magistrate, the benefit of prompting from the bench before whom the particular witness is appearing. None of that, and I don't repeat myself, was accorded to this particular person, and as I say, on at least 2 occasions, both his written explanation in the investigation and before the Mustard Tribunal, he said in those circumstances he would have been compelled to reconsider. Now, we have mentioned as well the fact that in the Warren case, which is at tab 10, as the head note suggests, a judge, whether of the High Court or any other court, was not a compellable witness in relation to his judicial functions. We have to accept, of course, that there is a first of all, we do say that this was related to his judicial functions in the sense that he was being asked to give evidence about an approach by an outsider, in this particular instance the Chief Justice, seeking to influence the way in which he determined the outcome of the Panday trial. So this certainly isn't, for example, given by Lord Wolfe, then the Master of the Rolls, where a judge sees a murder committed in the face of the court. This non-compatibility doesn't obtain there because it's nothing to do with his judicial function. We, of course, have to accept that there's a difference between not being compelled and not being entitled. But again, the public policy, which is referred to by Baron Cleavesby in a classic statement, does suggest that it isn't appropriate, really, to invite judges to give evidence in relation to their judicial functions for reasons that are too perhaps obvious to repeat before a board of this particular stature. Now, my Lord in the chair did ask me, well, did not he admit to Lord Mustill that on reflection his position was not tenable? And I have to accept that that is the evidence that he gave, but accepting that a position is not tenable is not, in our respectful submission, tantamount to making an admission of misconduct. I've had previous occasion to argue before the board that there's a difference between falling short of the best standards and actually being guilty of something that should attract a sanction, and that's the qualification I would make to the answer that I gave impromptu to my Lord the President this morning. It's also, perhaps we would just add and perhaps summarise this point by saying, well, firstly, he didn't refuse to testify. Secondly, it's not clear that he could have been required to. Thirdly, actually, we say the dilution of the charge, in fact, removes its essence. Although it's been suggested from time to time that there's no bright line between the present allegation and the present charge and the initial allegation, we, with great respect, say that there is a clear difference. The refusal to testify is a contempt of court. It assumes, at the very least, a duty. It also assumes, again, that one has no reasons at all. The Chief Justice had reasons that the board may think were imperfect reasons. His concept that parallel proceedings, something he derived from the board's opinion in the Sharma case, could be read across to this situation, that it was therefore inappropriate to have criminal matters pursued before a full inquiry. All those were reasons that it's not suggested, as I understand it, presently suggested, he clearly didn't have. He was just mistaken in relation to that. And we've again cited in the Jurity case at paragraph 24 the fact that if one misunderstands the law, it doesn't mean that one's necessarily guilty of misconduct. In that particular case, it was a case about someone, a magistrate, who refused bail on terms that a higher court judge had said were acceptable, and that's where the board made that particular observation. So, in our respectful submission, now the charge has been downgraded to focus exclusively on a conversation had between prosecuting counsel and the Chief Magistrate on the morning of the 5th of March, not in court, many hours before the court proceedings started, and in circumstances where, I repeat for the last time, the Chief Magistrate was never given the opportunity to repent, never asked to take legal advice, never prompted by the Chief Magistrate, and never in the end refused, which would be a contempt. In a sense, the very essence of that which would have been a proper charge had it been capable of being made out of the fact, in our respect for submission, no longer remains one. And although those are points that are open to the Chief Magistrate if the disciplinary proceedings continue, in our respect for submission, if the charge is actually unsustainable, it really doesn't serve the ends of justice not to abort the disciplinary proceeding at their earliest juncture. And finally, of course, we do make the point that the charge as presently drafted has two limbs, one of which is indication will not give evidence, second of which is thereby causing the termination of the criminal proceedings. And we do say in relation to the causation, in particular, if one seeks to attach this to the conversation in the early morning, one doesn't recognise here that the prosecution had a choice. The prosecution could, for example, have said, can we adjourn so the Chief Magistrate can take legal advice? The prosecution could have invited the magistrate presiding over the proceedings to give certain advice to the Chief Magistrate. The prosecution could have invited an adjournment in order that there should be reconsideration of this matter. None of these steps were taken, and actually, although one can't say there's no causal link between the Chief Magistrate's declared intention and the decision of prosecuting counsel, the prosecuting counsel did have options, and prosecuting counsel's decision, it was actually vindicated by the Deputy DPP that the step that was taken was the appropriate step. So that's the third point. And the fourth point I really make very shortly indeed. We would, and I've read to the board the salient paragraphs in the Mustill inquiry cross-examination. What we say about that is this. On the whole, it is not, it's regarded as unfair, other than circumstance in which exceptions have now been made by legislation and otherwise, for a defendant to a criminal trial or to disciplinary charges to be compelled to make out his defence in advance and then, this is the important point, to be cross-examined on it. We've cited in our printed case at paragraph 62 and 63 certain dicta from the well-known case about entrefois acquit from Lord Devlin and Lord Pearce in the Connolly case. Obviously, the read across is not exact, but the flavour of the observations of those two members and previous members of this board were that it really isn't fair to, as it were, test and retest a defence, and then after you may think that the defence has itself already been exposed as without substance, then to bring charges in consequence of that. The defendant ought to be allowed and enabled to keep his powder dry, and that, in the particular circumstances of this case, was not a right that was accorded to this defendant. So for any or all of those four grounds, we respectfully invite the board to bring these proceedings to an end, unless I can assist you further. Those are...
Thank you very much. Mr. Benjamin, is there
My Lords, I have nothing further to add. I'm grateful.
Yes, Mr. McNicholls. Pass the rostrum and then forward to me.
Can I just make one or two observations on facts first, and I'll get into the fourth question. Can I just clarify the chronology? Mr. McNicholls, the appellant's original statement was given on the 5th of May 2006. You see that at page 1740 of the record. I don't press take you now. That's not made to the police. On the 8th of May 2006,
the Chief Justice makes a written complaint to the Commissioner of Police about two things. First of all, the appellant's complaint, which had been made a few days earlier, and secondly, about an allegedly dubious land transaction in which the appellant was involved. Now, on the 11th, 17th and 24th of May and the 13th of June 2006, the appellant makes a series of statements to the police, and I emphasise to the police, on interview. So they're clearly not statements which are going to be used just for Section 137 proceedings, which at this stage haven't been brought at all. Can I just ask you to look at one or two points in those statements? They are detailed statements which make a lot of serious allegations against the Chief Justice, but in particular, can I take you in the Supplemental Record Volume 2, where you find the documents, just the one or two extracts from that, because it is clear from these statements not just that the Chief Magistrate thought that perhaps things weren't quite right, but that he formed the clear impression he was being improperly influenced. And you can pick it up in his first statement to the police, which begins at 1747. You can pick it up on the third page.
Sorry, 17?
46. It begins, this is his first statement to the police. It begins at 1747, I apologise, 1747. And on the third page, he's already described certain conversations he's had with the Chief Justice, but he talks in particular, in the third paragraph down on the third page, about a discussion with the Chief Justice in his chambers while the case was, I think, still going on the 21st of March 2006. And you'll see about 5 lines down, the meeting began with the Chief Justice congratulating me on the manner in which I was conducting the Panday matter. He told me I should pay particular attention to what Mr. Newman had to say, because he was very good. I responded to the Chief Justice telling him I found Mr. Newman to be very good. Mr. Newman was the lead attorney for the defence of Mr. Panday. I cannot recall Mr. Sherman telling me anything else about the matter that day. I formed the impression that the Chief Justice was trying to give me a subtle message that what Mr. Newman had to say would be essential to the outcome of the case.
This is Mr. Alan Newman.
It is indeed. And then, importantly, I am convinced, this is the point I want to make, I am convinced that this statement by the Chief Justice was designed to influence my mind, to rule in favour of the defence. I say this because in the normal course of a trial, the presiding magistrate must pay close attention to what both sides have to say before arriving at a conclusion. I reported that conversation to the Attorney General. So he knows the full seriousness of what he's alleging. And then you go over the page after further incidents. He reports at the top of the next page. This is another meeting, and I think this meeting is now taking place after he's finished hearing the evidence. Top of the page, having listened to what, page 1750, having listened to what the Chief Justice had to say, I didn't reply, nor did I raise any of the matters I wanted to raise with him, and left immediately thereafter because I didn't think it wise to raise any other matters with him because of the things he told me. As the Chief Justice, Mr. Sharma ought to have known that what he was saying to me was likely to influence my mind in the outcome of the matter of the police versus Mr. Basdia Pandey, and because it was important for them to keep my mind free of any influence, I did not return to see the Chief Justice before I gave my decision in the matter. And then dropping down a few paragraphs, to the paragraph beginning on Monday, the 1st of May 2006, he recites another meeting, and he says hello to the Chief Justice, and then you get to about 6 lines from the end of this paragraph, beginning, by this time, the tone of the Chief Justice's voice had changed, become more aggressive, evident from his facial expression. And the Chief Justice then asked me if he ever influenced me in any matter, and I told him no, but I really meant yes. But I said no, because I wanted to avoid an unpleasant scene. Only the Chief Justice and I were in his office, and I didn't know how the Chief Justice would have responded if I had said yes. And gives a reason for that. And then he finishes off his statement on page 1751 with the final paragraph. I consider the approaches the Chief Justice has made to me on the matter of the police versus Pandey to be inappropriate and tended to exert undue influence on me in the discharge of my judicial function. The first occasion any Chief Justice approached me to influence my decision. So I make this point, my Lord, because the magistrate must have known he couldn't have been making more serious allegations which were bound to lead to a criminal investigation, and he's making it the police at the time. My Lords, the consequence of this is that charges were laid on the 14th of July 2006 against the Chief Justice, but the proceedings were stayed pending the outcome of the Chief Justice's judicial review proceedings against that until the 30th of November 2006, when the Privy Council dismissed the Chief Justice's judicial review application in the case which you have at tab 9 of the authorities bundle. I don't propose to take you to that. So the consequence is, from then on, criminal proceedings are back on foot. In January, it seems in about January 2007, the prosecution decides to proceed at the preliminary inquiry by way of written statements, rather than the usual long-winded process of getting everyone to give oral evidence. And you can see that from the Deputy DPP statement, which you've seen at E10, or the embargo documents at tab 10 in her statement. She explains that. We decide to proceed by way of written statements, and the lawyers acting for the Chief Justice then request all those statements. And my Lords, can I just take you to the requests that are made for the statements, which you see at tab 11 of the embargoed documents. You can see them being made, setting the chronology, in January of 2007 and early February 2007. And if you go to tab 11, you can see, I think, as exhibits to the Defence Counsel's statement, you can see on the 24th, about, I imagine, 10 or so pages in, you can see a letter of the 24th of January 2007, a letter of the 2nd of January 2007, about 10 pages in, from the junior attorney acting on behalf of the Chief Justice to the Deputy Director of Public Prosecutions. Attention, Miss Carla Brown-Antoine, about 10 pages in. I act as junior counsel to the government accused, in keeping with the well-established common law rules for making disclosure. I would be grateful if you could make available to the defence the following materials: list of the ordered witnesses, and then copies of all witness statements, including those upon which the prosecution does not propose to rely. And you can then see over the page various other things which are sought. And then you can see a few pages on, 24th of January 2007, the DPP sends over some statements to Mr. Persad. And then again on the 31st of January 2007, various other statements are sent over. You see again, sequential letter. And then again, 6th of February, further statements are being sent over. Now, none of these statements yet include the statement made by the Appellant, the Chief Magistrate. Now, on the 13th of February, I emphasise the 13th of February, you have the Chief Magistrate's letter, which you've already seen at page 1761 of the record, where he says he's got wind of the fact that there's going to be Section 137 proceedings, and he doesn't think, therefore, it's appropriate to proceed by way of criminal process. But on the following day, on the 14th of February 2007, he does nonetheless swear his statement, and he's, in other words, not just giving it sworn it. You can see that in this same tab, at tab 11, on the 14th of February, his statements are sent over on the 14th of February, already sworn. Now, my Lords, on the same day, the 14th of February, one has to pick this up from a rather different reference. On the same day, one or about the same day, the Chief Magistrate indicates a reluctance to the DPP, to the Deputy DPP, and it seems to Mr. Peterson, about giving evidence. That's, it seems, on the 14th of February 2007. And one gets that from his own application for judicial review of these proceedings at page 10, paragraph 11 of the first part of the record. And perhaps I ought just to take you to that reference. It's paragraph 11, page 10. This is the Chief Magistrate's own claim. On the 14th of February 2007, the applicant swore witness statements to the same effect as his complaint against the Chief Justice, but indicated to the DPP, Mr Henderson, the Deputy DPP, Ms. Carter-Brown-Antoine, and lead prosecutor Gilbert Easton, that he was reluctant to give evidence in the criminal proceedings. And then it goes on to say that he was nonetheless urged to reconsider. I think it's common ground between my learned friend and myself that around the same time both the DPP and the Attorney General urged the Chief Magistrate to reconsider his position. And you get that from the agreed statement of facts and issues in paragraph 14. And also page 54 of the first part of the record, paragraph 22. The preliminary inquiry hearing begins on the 26th of February 2007. Paragraph 22, page 54. This is the Chief Magistrate's affidavit in the first part of the record. Page 54, paragraph 22.
What page numbers is the person employed by solicitors cut off all page numbers.
Well, I do apologise, my lord.
What is it at the top?
Number 2 affidavit of Sherman McNicholls, shown to me annexed and marked SM6.
The left-hand page is all right.
Oh, left. Yes,
I think we've got the left-hand page.
We've got 53 in the left-hand page. We don't have 54 in the right-hand page.
I've got 54 on the left-hand page. Something's good.
We're there anyway. We're there.
We found it.
Right. You can see, I hope, paragraph 22 is what matters.
Yes.
So, he's basically urged by the DPP and the Attorney General, well, reconsider. And that is sometime after the 14th of February 2007. Then, on the 26th of February, the preliminary inquiry actually begins, and that's what you get out of paragraph 22 of the Deputy Director of Public Prosecution's statement. My lords, my lady, can I just take you to that? Because it's rather important what actually happens around this part of the chronology. That's in the embargoed material. In tab 10. My lady, I apologise, there are no page numbers on this, but it's about halfway through tab 10. Her statement of the 28th of March 2007. And I think you've been taken to paragraph 21 already, when she says she went to see Mr. McNicholls and says she hasn't answered his letter. But in paragraph 22, the preliminary inquiry begins on the 26th of February 2007. And then paragraph 23, at the end of this process, that must mean on the 26th of February, defence attorney for the Chief Justice indicated that the only witness they required for cross-examination was Mr. McNicholls. He's the only chap they want to ask any questions of. At that time, Mr. McNicholls was presiding over a preliminary inquiry in a court nearby. The prosecution indicated to the court that it would not be proper to interrupt the proceedings over which he was presiding in order to inform him that he was required to testify. The matter was adjourned to Wednesday, the 28th of February, for Mr. McNicholls to attend for cross-examination. On Tuesday, February 27th, at around 10 a.m., I visited Mr. Sherman McNicholls in his office to inform him that he was required to attend court the next day at 1 p.m. He told me for the first time that he wanted to make his position clear, that he wasn't going to give evidence in the criminal proceedings. We discussed the implication of his decision. After this conversation, I had no further communication with Mr. McNicholls before the case was discontinued. Then she refers to receiving a letter from the Attorney General. And then paragraph 26, she drafts the response to Mr. McNicholls' letter you've seen, which she faxes over. And then on paragraph 27, when the matter comes on for hearing, she's informed by the DPP that Mr. McNicholls had called to indicate he wasn't going to attend court to testify on the matter, but he was unavailable on the 28th of February, but he would be available to attend court on the 5th of March. He also indicated that Mr. McNicholls requested copies of his 4 sworn statements. I gave copies of the 4 sworn statements to the messenger for delivery. That day informed Mr. Peterson of these developments. He indicated that since Mr. McNicholls was going to attend court to give evidence, we shouldn't send the draft response. So, my lords, at that point, Mr. McNicholls appears to be equivocating. He might be suggesting, well, I will be attending. And then, paragraph 28, I was present and heard Mr. Peterson inform the court of the position of the witness as stated above, and so the matter is adjourned to the 5th of March. And, my lords, the importance of that is that on that date, Mr. Peterson gives what he regards as an undertaking that that the appellant is going to attend court on the 5th of March. And we pick that up from Mr. Peterson's statement, which is at the end of tab 11, near the end of tab 11. In the second paragraph, he explains why it was, he explains what he said to the court on the 26th of February, and why it was that he wouldn't be able to get Mr. McNicholls along for the 28th of February. That's in the second paragraph, my lords. It's about 5-6 pages from the end of tab 11. The second paragraph explains what happened on the 26th of February from Mr. Peterson's point of view. And then the third paragraph, when the matter was called on the 28th of February, I gave an undertaking to the presiding magistrate that Mr. McNicholls would be present in court on the 5th of March for cross-examination by Mrs. Elder. The matter was then adjourned to the 5th of March 2007 at 1 p.m. My lords, of course, at this point, the prosecution think that Mr. McNicholls might be prepared to attend. And then you get the next paragraph, the morning after the 28th of February, i.e. the 1st of March, Mr. McNicholls called at my office at about 8:40 a.m. In that conversation, he told me he wanted to make his position clear that he was not giving evidence in the criminal proceedings, and had already written to the DPP to that effect. It's referring to the letter you've seen. And then Sunday the 4th of March, at the foot of the page, he tries to get hold of Mr. McNicholls at his home and leaves various messages. And then you can see how the matter develops on the 5th of March itself. The fourth line down, in the morning, Mr. McNicholls said that he again wanted to make his position clear, that he wasn't prepared to testify on the matter. I said, okay. And then, my lords, one has what we've seen in the record of the Section 137 proceedings. One can pick up, as it were, one can fill in some of the gaps at least, by looking at the Section 137 proceedings at page 1723 in exhibits, the slim bundle. And one can see his state of mind.
At page
1723 of the slim. It's called Exhibits as Contained in the Supplemental Record. It's the rather thin one, which has got the...
It's volume 1. Well, mine's not quite short.
Supplemental Volume 1, yes. Mine hasn't got a number. And you've seen this already, but I'm just trying to piece it all together again. Page 1723. This is examination by Lord Mustell, part of the examination by Lord Mustell, beginning at 1722, halfway down the page. But when you get to 1723, about two-thirds of the line, two-thirds of the way, halfway down the page, so you must have been a big surprise to the magistrate, everything appearing to be in order, and there was a witness statement from you, that suddenly a puff of wind and the prosecution collapses. Was that not a surprise to you? Yes, when I turned up that afternoon, sir, it was out of respect for the court. I didn't go prepared to testify that day, and I was not expecting to be called into the courtroom. And then that point is picked up over the page at 1724, line 5. This is now a cross-examination by Mr. Morrison. Sorry, I just wanted to ask you, sir, on the subject of the adjournment. You expected an adjournment to what end for a period of time, and then I would have reconsidered my position. Then over the page, he's pressed about this answer, over the page at the top of the page. But I'm a bit curious about it myself, sure. On what basis? Just tell me, what was your state of mind? Because as I've said, I was hoping that the state would have gotten an adjournment of the matter, you see, and then with the passage of time I would have been able to better decide what I wanted to do, but I wasn't given that opportunity. And Sir Vincent Frossack asked, but did you ask the state to apply for an adjournment? Witness, I told the state that, yes, sir. Now, my lord, that is obviously a
That was to apply for an adjournment, though, because of the duality of the proceedings.
Yes, exactly, yes, yes.
Not in order to allow the Chief Magistrate to change his mind.
Well, did you ask the judge to apply for an adjournment? My lord, it's not clear
But if you go back to 1724,
yes,
where he says here, you'd already expressed the view in writing of the DPP that the prosecution not proceed, should be stayed, and then 2 or 3 lines further down, line 16, the dual proceedings, I think is the substance of what you're saying. I mean, that was the underlying basis upon which he had been saying all along that the criminal proceedings should be adjourned.
Yes, exactly, yes. And my lords, then one picks it up at 1729. Fourth line down. Miss Brown says that you should go into the witness box and state your position, but Mr. Peterson spoke to you at the prosecutor's table. What did he say to you? I think he might have asked me if I wanted to go to the witness box to say that I wasn't giving evidence. Right. And I said no. He said no. Yes. He then indicated that Mr. Peterson said this wasn't necessary, and you left the court when the magistrate discharged the accused. There's no truth, is there, in your statement? There is truth. And he goes on to explain what his position is. My lords, one can get an idea of what the position was at the time if you go to the supplemental record, volume 2, the press release, which the appellant himself issued on the 6th of March, the day afterwards. And in my submission, when you look at this statement, there's only one way to read it.
And what page is this?
1770. Supplemental record, volume 2, page 1770. And you'll see the reason at the top of the page why he's giving this statement. A great deal has been reported and said about the events of last evening. I break silence, the silence normally expected of a senior judicial officer to dispel some of the unfortunate and scandalous assertions. He then goes on to justify his position, but the justification is entirely with reference to the concurrent section 137 proceedings, and that in particular, the last 2 paragraphs on page 1770. As a judicial officer, I form my own decisions on the law based on precedent and facts, and without reference to who is before the court. I show no partiality, and I deliver justice without fear or favour. I cannot be bullied. Once I've examined the law and arrived at a conclusion, I stick to the conclusion. What has occurred, in fact, is that statements have been taken from me for use in both sets of proceedings, in my view, in defiance of the guidelines provided by the Privy Council in the Sherman matter. And then he goes on to explain what he did last evening. In keeping with his position, I affirmed I was willing to give evidence in the proceedings under section 137. Statements have already been given by me to this end. And my lords, I submit it's clear what he is doing here. He is justifying his refusal on the previous day to give evidence. It's as simple as that. There's no equivocation at all. And, my lords, that is the same, that same picture emerges from the written explanation that one sees in the same bundle here.
The refusal being given in the early morning of the 5th.
On any footing, yes. I mean, because that's the refusal he admits to, as you see in his statement at explanation at 1780.
And that's the refusal you rely on, is it?
My lords, that is, well, my lords, the way the charge is framed, it doesn't actually say which refusal is the libel. I accept that. But I submit it would be open to the respondent to say, well, we've said on the 5th of March, and if there was more than one refusal on the 5th of March, then we'd be entitled to allege both refusals.
And what's your case about when the second refusal, if there was one, at the table took place? I'm not saying this is directly relevant, but it's a bit obscure what the true position is there, at any rate to me.
Well, my lords, there's certainly one refusal in the morning to Mr. Peterson. There's no doubt about that. It would seem that...
That was, however, not at the court.
That would be outside the court, presumably, yes. Then there is also...
It's on the telephone.
Yes, on the telephone, yes.
It wasn't on the court at all, was it?
No. And then there's, as well, the confirmation of position, which is not directly referred to, I think, in Mr. Peterson's note, but in fact does appear to be admitted by the appellant himself.
Oh, Mr. Peterson mentions another telephone conversation between 10 and past 12 and half past 12.
Yes.
On the 5th. That's lunchtime, I take it.
Yes.
Just before the Chief Magistrate is due to arrive at court, asking him to give a statement to the police, setting out that he refused to testify and the reasons for his refusal. And Mr. McNicholls told me he didn't consider it necessary, since he'd already indicated his position to leading counsel.
Yes, so there's no need to repeat it. So it would seem there are two refusals. My lady, you're right, there are two refusals, it would seem, on the 5th of March.
Before he gets to court.
And then there is the confirmation of the position, as it would appear at least, in court itself, which emerges from the section 137 proceedings.
Seems to be a suggestion that might have taken place after the discontinuance had taken.
My lords, that would have to be, yes, if the matter would proceed, that would have to be investigated. And then you have the written explanation at page 1780. My lords, you've already seen this, and I don't want to go over.
Now, before that, though, we get the allegations.
You have the allegation at page.
This is the page 1781 is March the 21st. Is that right?
Yes.
But before that,
we
had the allegations. Which Mr. Justice Ventura was asked to
yes.
And where do we see those?
1778. Well, you can see it emerges in two places. It starts at 1774, which is the Service Commission's letter appointing Mr. Justice Ventura, a copy of which, as I understand it, is sent on that same day. You get that at 1773. Is sent to the Chief Magistrate on the 9th of March as well. So you have, that's the first intimation. So this is what he's told on the 9th of March. He gets the accompanying letter.
And this is the allegation that at the 4th A court, he refused to allow himself to cross-examine.
Yes, exactly. And then, my lord, perhaps more importantly, 1778, you get the actual direct letter from Mr. Justice Ventura. On the 15th, I think it's undated, but I imagine it must be the appellant himself, as marked received by me on.
No, it is dated.
15th of March. 15th of March.
Oh, sorry,
the
the standards covered it up, yes.
But that's a quotation, isn't it, from the thing we just
Yes,
said?
it's the same, my lord, it's the same, I think, word for word the same. The important phrase being refused to allow himself to be cross-examined.
Yeah.
And then page 1780, you have the explanation, which is the 21st of March 2007. You get that from the last page in 1782. And my lord, the explanation I submit is very important. The first point, which I submit is clearly accepted by the Chief Magistrate, is in the 4th paragraph down. he discusses his meeting with the Deputy DPP on the 13th of February 2007. You can see that about 7 lines down. At our meeting, I told her that when I made the complaint in writing to the Prime Minister, I did so with the clear intention of having the matter dealt with under Section 137. I also mentioned to her that I never contemplated criminal proceedings against the Chief Justice, made it clear to her that I cooperated with the police because of allegations of impropriety involving a land transaction were made against me by the Chief Justice. Since I was satisfied everything I did was above board, I had nothing to hide, I gladly cooperated. This is the important passage. I indicated to her also that I was not willing to testify in the criminal matter. She said she wasn't clueless about that. And then the next paragraph, as a result of my reflection on the matter, I was reluctant to swear to my statements. There was no response to my letter. That must be the 13th of February letter. Ultimately, I swore to them, under the clear impression that the Deputy DPP would revert. And then over the page, second paragraph down, coming up to the date of the Sherman criminal matter, I received telephone calls from the DPP urging me to reconsider my position. Ray testified in the matter. Then he says, I eventually swore to my statements. In fact, the chronology is slightly out, because he'd sworn to them on the 14th. And the matter was fixed for hearing on the 26th. And then he explains what happened about the dates on which he's told to appear. And importantly, the last sentence of this third paragraph, up to that point, and this would seem to be, looking at the rest of the paragraph, the 2nd of March, up to that point I was still undecided as to whether I would testify in the matter. And then during the morning of Monday the 5th of March, I telephoned Mr. Peterson and informed him that I was not willing to testify. He said okay, and that was the end of my conversation. And my lords, you've already seen the following paragraphs, but can I draw your attention in particular to the way the third last paragraph and the second last paragraph are phrased. I was making up my mind as to whether or not I should testify, and he examines the Court of Appeal's judgment. And then the last sentence in that paragraph, I came to the conclusion after a great deal of prayer and reflection that I should not participate. And then, in spite of the fact that I'd come to the conclusion not to testify in the matter, had the DPP or presiding magistrate indicated to me my reasons for not testifying, I would have testified. But, my lords, what I submit here is that what he is saying here is when I went into court on the 5th of March 2007, I had decided not to testify. Now, he's advanced.
Well, unless the magistrate said, look, your reasons are only bad, in which case I would have testified. Yes. If it had been pointed out to me that my point about having the stay was really bad in law and that the criminal proceedings must go on, then what this witness is saying in this statement is that he would have testified.
Oh, indeed. Well, my lord, all that, of course, will be a matter to be explored in
it's not sticking, having the courage to stick to my convictions. I can't believe that I stand by the courage.
Sorry. I simply make these points not to say that the Chief Magistrate would have no answer to the charge, but simply to say that there is plainly material to support the charge. That's the point I'm on. And he's made a decision. And that, I submit, is the natural interest draw. He decided not to testify, and that was the point of his telling Mr. Peterson that. My lords, that's what I wanted to say about the factual background. Can I now deal with Mr. Bellot's first ground, namely the ultra-vires argument? And my lords, I make two basic submissions in answer to that. I submit that, on any view, there was a sufficient nexus between the charge eventually brought and the allegation as first put to the Chief Magistrate by Mr. Justice Ventle. That is because, in broad terms, the effect of the Chief Magistrate's refusal to testify on the 5th of March 2007 was, in context, a refusal to be cross-examined. And that is because the only purpose of his attendance on the 5th of March 2007 was to be cross-examined. And so by saying on the 5th of March, well, I don't want to testify, he wasn't just saying, oh, I want to withdraw my statements. On the contrary, what he was saying is, I don't want to be asked any questions.
What about at court?
Well, my lords, if he says the same thing to Mr. Peterson again, It is a refusal to refusal
No,
to
no,
be.
but I mean, report of Justice Ventor was requested on an allegation that he refused to testify at court.
Well, my lords, it's the word order isn't quite that word order. I don't want to take. I don't want
If
to
he
take
said,
that.
I refuse to testify at court, that would be entirely ambiguous.
My lord, I think
That's
that.
what he was going to testify. The question is
Well,
whether
he
it was the
refused at
refusal.
court to testify.
Yes. Well,
He, on the 5th of March, at the 4th court, refused to
Yes.
allow himself to be cross-examined.
I agree. I agree. That, I agree, on the face of it, would appear to be.
Well, the recipient of the telephone conversation over lunch was at court.
One could put it that way.
Or the only point is there's stuff to argue about.
Yes, exactly. My lady, I fully accept the charge is not identical, but one can see the difference. I mean, because one can read the charge as original.
What's the principle? I mean, are you saying it's de minimis, which is
Yes.
Mr. Beloff's submission? Or are you taking a different point that if the explanation puts a different complexion on the report, then that's all right?
My lords, I'm taking 2 points. The first point is the sufficient nexus point, which is entirely self-standing. I say you look at the original charge and you look at the original allegation, I should say, or original report or allegation. You look at that and then you compare it with the charge eventually brought. If there is plainly a sufficient nexus between the two, such that the officer in question couldn't have been misled as to what the nature of the charge was when he originally saw it, then there is nothing ultra vires about a slight change in the wording, or indeed a slightly different charge that comes in later.
What's
That's the
it's
first.
a test of fairness, is it? I mean, if
Yes.
there's...
Yes.
All right.
My lords, the other point I take is, if in fact the explanation given by the officer himself gives rise to the charge as eventually brought, then there cannot possibly be any objection to bringing the charge which reflects his explanation.
Right, well now if you have to rely on that second point, that wouldn't cover the sotto voce conversation at the prosecutor's desk, would it? Because that's neither in the... Well, that's not in the explanation.
No, it's not.
I suppose it might be in the original charge, in the original allegation.
It would cover perhaps the paragraph referred to by Lady on page 1779.
The evidence is a little bit confusing about what happened at the prosecutor's desk, because what was put by Lord Muster wasn't quite what the evidence was. At 1729,
Yes.
Mr. Peterson spoke to you, prosecutor's table. What did he say to you? I think he might have asked me if I wanted to go into the box to say that I was not giving evidence, right? And I said no. He said no, yes. And he then indicated to you that Mr. Peterson said this was not necessary and he left the courtroom. As I understand it, the other account was that Mr. Peterson said that Mr. McNicholls said it wasn't necessary.
Well,
At 35, I'm now on the...
sorry, which I've now...
Yes.
I'm slightly...
Documents under embargo.
yes.
It shows there should be a law against unpaginated bundles.
Statement of the Deputy Director of Prosecution. Mr. Peterson then said to the court that he was calling Mr. McNicholls. After his name was called, Mr. McNicholls entered the courtroom and went to the witness box where he was about to be sworn. At this point, Mr. Peterson rose and told the court that, having regard to the position of taking a certain course, we're not proceeding. Mr. Nicholls came out of the witness box. I then indicated to Mr. Peterson the witness should go into the witness box and state his position. Mr. Peterson spoke to Mr. Nicholls at the table, and he indicated to me that Mr. Nicholls said this was not necessary.
Yes.
So, really, the question is what inference do you draw as to his attitude from his saying, no need for me to go and explain my position?
Well, my lords, in my submission, that no doubt there would be matters that would have to be investigated, assuming these charges get pressed and so on. But, well, just as a matter of law, what I submit is that when you're construing the regulations, if in fact there is a sufficient nexus between the charge as eventually brought and the original charge as put, then in my submission, the charge eventually brought is not ultra vires. Now, I'll come to the regulations in a moment. That's one submission. Then it might be a related but strictly separate submission as well, as long as the offence as charged arises out of his explanations, fairly arises out of his explanations, and that's another basis for bringing the charge. And so on that latter basis, as my Lord Mance pointed out, on any footing, the charge can proceed in relation to the conversations with Mr. Peterson early on the 5th of March, or lunchtime the 5th of March.
Charged with hitting the victim with a walking stick. He replied, didn't hit him with a walking stick, it was with my golf club.
Yeah.
And then the final charge is hitting him with a golf club.
Yes. And in my submission, that's also a basis on which the charge can stand without being ultra vires or unfair.
Just going back, Mr. Knox, for a moment to the actual wording of the original charge at the Fourth Court, could it not be said that this is a reference really to the Chief Magistrate maintaining his earlier refusal not to be cross-examined? He'd made it, if you're right, quite clear that that was his position. Come the time when he was required to be cross-examined, he wasn't. Now, we know the circumstances in which he wasn't, but could it not be said perfectly reasonably that that is the moment when his refusal actually took effect, or matured, or bit, or whatever you like to say?
I think that was the point I was trying to get at, and I said this hasn't been worded particularly well, but the point is, at that point, he is still refusing to be cross-examined. He hasn't resigned from the previous position, namely, actually, now I'm here, come on, I'll go into the witness box. He's gone into the witness box, but he knows at that point what is going to happen, namely, he's not going to be asked to be cross-examined.
I must say, it strikes me that this isn't to be a complete game. Where the actual averment is made is an almost entirely irrelevant averment.
Yes.
I mean, whether he refuses it in his bath, when he's having a telephone conversation, when he's lying in the bath, or whether he's at the court door, seems to me to be neither here nor there. It's the substance of the thing which is what the case should be about.
Well, my lords, that's the point I'm trying to make. There's sufficient nexus between the original charge and the eventual charge. Otherwise, but my lords, can I develop the submissions by reference to the regulations themselves?
Yes.
Now, there's no doubt these regulations do apply. That's conceded. There's absolutely no doubt about that.
My lords, there's no doubt about it at all. As I understand it, it's common ground between us that they do apply, and they were taken to apply in a previous decision of this board in relation to similar. Well,
In the majority case.
Majority, yes.
There is, however, an intervening piece of legislation, which is the Judicial and Legal Services Commission Act, that intervenes between the Constitution and the regulations.
Yes, my lady. Yes.
Which may or may not contain anything of any use to us, but it might be helpful to have it. It's certainly the piece of legislation that lists the Chief Magistrate and magistrates as people to whom Section 111 of the Constitution applies.
Yes. Well, my lady, I'm sorry, it is not in the authorities bundle, but I think we will...
Speaking myself, I think it would be very helpful to have it, just in case. It might be.
Well, I'm going on recollection of something a long time ago.
Can I go to the regulations?
Yes.
On the footing that they apply. Tab 13 of the authorities bundle. I could pick it up in regulation 90. And what I rely upon is the way the regulations are drafted. It suggests that the original matter which has to be brought to the attention of the officer is a report or allegation. Section 90, or regulation 90, subparagraph 1, where a report or allegation of indiscipline or misconduct is received. And then you have the procedure setting out what's to happen. And then subparagraph 3, which takes you to the investigating officer, investigating officer shall, within 3 days of his appointment, give the officer a written notice specifying the time, not exceeding 7 days and so on, within which he may, in writing, give an explanation concerning the report or allegation. And then subparagraph 6. The Commission, after considering the report of the investigating officer and any explanation given under sub-regulation 3, I emphasise, obviously, any explanation, shall decide whether the officer should be charged with an offence. My lords, I emphasise an, it's not the offence.
You've hopped over 5, which refers to the particular act.
Oh.
And these regulations are a bit confusing, and sometimes they talk about an alleged act of indiscipline or
Yes.
misconduct, and then the next regulation they say charged with indiscipline or misconduct.
Yes. Well, I was going to come back to the meaning,
Right.
because my learned friend draws attention to that. But just looking at subsection 6.
But any explanations are reference back to sub-regulation 3.
Yes.
So this isn't the accused's explanation, is it?
Yes. In my submission, that's exactly what it is. Yes.
The officer.
The officers, in other words, the officer under attack.
Oh, I see. Within which he, yes, I see. That's the officer, yes, I beg your pardon. Yes.
So in my submission, the structure is that you get the reports, the investigating officer gets the reports, and he also gets the explanation. The explanation is then put to the Commission, who then considers the report, and any explanation given under sub-regulation 3 shall decide whether the officer should be charged with an offence. And if the Commission decides the officer should be so charged, the Commission shall, as soon as possible, cause him to be informed in writing with the charge, together with such particulars as will leave the officer under no misapprehension as to the precise nature of the allegations on which the charge is based. Now, my lords, I submit, and then, subparagraph 7, where in the explanations given under sub-regulation 3 the officer makes an admission of guilt, the Commission may determine the penalty to be awarded without further inquiry. Then sub-regulation 8, where the Commission under section 127 has delegated to an officer its duty of deciding under sub-regulation 6 whether an officer should be charged of charging such officer with an offence, the reference to the sub-regulations shall be construed as a reference to that officer. My lords and my lady, I submit that it is clear what this is envisaging, or rather 2 points are clear from this. First of all, that it is open, and that is particularly apparent from sub-regulation 7, it is open to the Commission to look at just the explanation and say, well, you may have confessed and avoided, but even what you have said amounts to an offence, and we are going to impose a summary penalty as a result.
So if the allegation alleged murder and the explanation was that it was only a punch and the only caused him bloody nose, then he could be sentenced for bloodying the nose.
Yes, I mean, when assuming as well. Yes, exactly. And in my submission, therefore, one is entitled. The Commission is perfectly entitled either to dispose of it itself or simply say, well, this arises on your own explanations. The second thing I submit that one gets out of this is that precision comes in at the stage of a charge. There is no requirement for precision before then. I mean, obviously some requirement for precision, such as to enable the officer to give his explanation, but there doesn't have to be the sort of precision which is provided for by sub-regulation 6.
Yeah, but the point against you is that's all true, but you can, so to speak, contract. You can't expand.
Well, my lords, I submit that is not a fair reading of these words. If in fact the nature...
shift. You can't either expand or shift.
Well, my lords, in my submission, as long as it is the eventual charge is sufficiently related to the original charge, such that the officer, when he sees the original charge, knows what the case is about, then in my submission there's no reason why he can't be charged with what is eventually charged.
But in Regulation 5 there, subparagraph 5, you've got this reference to report on the particular act.
Yes.
And that, as I would read it, when I was speaking for myself, that suggests it to be contrasted with a report on the allegation. It's a report on, if you like, the conduct or the incident which has given rise to the allegation. So it's thereby suggesting that there is a
something wider than simply the wording, whatever it may be, of the allegation itself.
Indeed, the act, in other words, what it is that he is said to have done, as opposed to report on the offence charged.
Well, there is no charge at that stage.
No, or the allegation.
It's the allegation would be the thing
Yes.
to be contrasted.
There won't always be a specific act one can identify. Maybe a course of conduct, knocking off lunchtime to go and play golf every day.
Yes. My Lord, in my submission, all subsection 5 saying, well, that's an act. There will have been some misconduct or indiscipline which caused the allegation to be made, and then that is something that the investigating officer has to report on. That's all it's saying. So then the Commission can make up its mind by reference to that, and indeed any explanations which are advanced. But my Lords, I emphasise, what I rely on, in essence, is the reference to any explanation, and that clearly can be taken into account, and the words an offence, not the offence. If my learned friend was right, really, it would be the offence, and you wouldn't have the structure which seems to leave it to subsection 6. That's the stage at which a precise allegation is made. My Lords and my Lady, there's one other point, namely the contrast between this procedure and what one sees in regulations 103 and 105. Because once the charge has been made, there is specific provision made in regulations 103 and 105 for what is to happen when the charge is actually on foot, but then it seems that another charge should be brought instead. And Regulation 103 deals with a position where there's just one officer who is acting as the disciplinary tribunal, and it appears that the penalty that could be imposed is one of those specified in regulations 110(1)A to E. Then there's a provision for an adjournment for 14 days, so he can provide a report to the Commission. And then subparagraph 2, where such officer receives a report, that is to say the officer to whom a report is made, he shall submit that report to the Commission, and if in the opinion of the Commission, A, the officer should be charged with an alleged act of disciplinary misconduct, the Commission shall cause the officer to be so charged, and the proceedings before the disciplinary tribunal shall cease, or B, the officer, on the finding of the facts submitted, may be liable to any one of the penalties in B to E. The Commission may direct the disciplinary tribunal to continue the hearing of the evidence, find the facts and make a report to the Commission. And my Lords, what that appears to be envisaging is that where it looks as if a penalty short of dismissal could be imposed, then a different charge can be proceeded with, just like that. If, however, the penalty is going to be dismissal, then the Commission has to say stop. And you get that by going over to 110A to E.
Section 103 is only about one officer,
Yes.
where there's one
Exactly.
member of the tribunal. Is that
Yes.
right?
That's right. And then the position where there are 3 members of the tribunal is dealt with in Regulation 105.
Other misconduct or indiscipline means what? Misconduct or indiscipline other than that
Yes.
charged under under Regulation
Yes, it must.
90.
Yes.
All right.
But the point is
And
that
then you
there
have to
is-
start again.
Exactly, then you've got to start again. But what is my submission is significant is that there is a specific provision made for what happens if, once the charge has been brought, it looks as if another charge ought to be made. Then the specific procedure is set out. Now, my Lords, in my submission, one would have expected, my learned friend Mr. Belloff's construction was right about how the original allegation was made. One would have expected to see a similar process, but there's no similar process at all envisaged in the regulations. And in my submission, the reason for that is this. If, taking my submission that an allegation arising out of an explanation can be made, if in fact in giving his explanation, the officer has admitted to that which is an offence or is arguing an offence, then it would be absurd to say you've got to start the process all over again.
Whereas if he makes his admission at the hearing, then what?
Well, if he makes it, well again, in that case,
Then you have to start all over again.
Well, my lords, no, because not necessarily, of course, it depends what type of charge you're bringing. But my lords, certainly at the earlier stage, in my submission, it would be absurd to require the investigating officer to begin the process all over again, if the offence arises out of his own explanations. The second thing in my submission is this. This is on my nexus argument. If there is a sufficient nexus between the allegation originally made and the charges eventually brought, the effect of my learned friend's submission would be to create a series of unnecessary satellite litigation.
As a matter of interest, I mean, if we're trying to understand this, as a matter of interest, so when can you have disciplinary proceedings before one officer? Presumably, when it's very, very small, there must be some provision saying that there are certain disciplinary matters which attract a very low sentence.
I'm not entirely sure, because of course the premise is that some of these you might land up being well. If you look at what can happen to you, you go to section 100, regulation 110.
No, that's the premise of 103 is that there are certain disciplinary proceedings which could not involve one of the 110 penalties.
Yes, and then
so it must be much lesser ones.
It could involve a reprimand or a fine, but not one of the big ones.
I see. So there are some which could only involve a reprimand or fine, yes.
My lords, it's not. I don't want to waste your time.
I think that's F
problems
and
of
G.
referential drafting.
That's right. It's F and G. Exactly.
Yes?
Yeah.
Anyway, section 95 is the section which applies to this commission as the other. Is it? Yes.
Yes.
Notwithstanding the statute my lady referred to.
No, it's regulation 95. So, my lords, that's what I say on the proper construction and regulations. Can I just deal with the question of prejudice? My learned friend says there was prejudice, but I make 3 points on that. First of all, the Chief Magistrate's right was to give only an explanation. He did not have the right to debate whether or not the facts amounted to misconduct. I say that's because that's what the regulations say. You have the right to give an explanation, not to make submissions as to whether or not you should be charged. Secondly, in his explanation, the Chief Magistrate does not base...
Why is that? Why can't explanations a pretty wide sort of expression, is it? Why would they include some defence as a matter of law? You're charging me with this misconduct, but it doesn't amount to misconduct.
Well,
I admit the allegations, but they don't amount to misconduct.
There would be nothing...
Why isn't that an explanation?
There would be nothing to stop you giving the explanation, but in
But
my
that
submission,
would be an explanation, is my point, surely.
well, in my submission, not. Respectfully, not. to say the explanation is what do you have to say about this as a matter of fact, rather than, well, what submissions do you have to make about
Well, that would be a very odd, narrow construction in a disciplinary process, which is going to subject somebody to what might be very serious disciplinary proceedings.
My lords, the
You have
right...
a cast down defence as a matter of law. Why shouldn't you put it?
My lords, the right to give, the right to make submissions of law at the beginning of the hearing are reserved by...
Long before the hearing, at the very outset, why shouldn't you say, look, this is perfectly ridiculous?
Well,
Let's move on to the next point, shall we?
The fact is you can make it at the beginning of the hearing, as you say, under section 98(3).
yes.
Yeah.
Anyway, my lord, the second point is this. The Chief Magistrate doesn't, in his explanation, base his defence upon, look, I didn't refuse to be cross-examined. That's not the line he takes. What he says is, what he does is he justifies his approach in his explanation. He says, well, if I'd been told this was if I'd been told that I shouldn't be taking the point I would have taken, I would have taken a different line. But what he doesn't
I wouldn't have refused.
Sorry?
I wouldn't effectively have refused, is what he'd be saying.
Well, exactly. But my lords, there's no question here of him saying, there's no question of him not knowing what he was being charged with. He gives the answer which he needs to give in his explanation. This is not a case of a charge being brought, which is quite misleading. And so he's not in a position to put his best foot forward. He knows what the nature of the allegation is, and he puts forward his explanation. And one can put it this way: supposing he had been charged with the charge that was eventually brought, what real difference would there have been in his explanation? In my submission, none. My lords, can I move on to the second ground? Which is
failure to keep confidential on that.
yes, yes.
I don't think we need trouble.
My lords, I don't know which other grounds you want. There were four. I've only addressed you on one. That was the main ground. I don't know if you want me to hear you on the other. There was the no case ground, and then there was the general unfairness ground because of the other proceedings. Well, my lords, those are my submissions.
I'll deal with the brief point in relation to the first charge on the basis of fairness. First of all, of course, we accept and contend that an explanation by way of defence of fact and law, and it would be an extraordinary reading down of these regulations to conclude otherwise. And secondly, in any event, in our respectful submission, general rules of natural justice which could be used to supplement regulations of this kind would permit, indeed would certainly not exclude, the widest possible response to serious charges of that kind. As to the submission made, well, in point of fact, he would have said nothing different. The answer is, how can we know? His attention was not actually directed towards the charge as presently drafted. I'll just then deal very briefly with the factual points made at the outset and then conclude with the question on the construction of the regulations, the only matter my learned friend has been invited to address you on. Of course, the Chief Magistrate recognised the seriousness of the allegations that he was making. His point has been, from first to last, that he considered that as and when a Section 137 procedure was contemplated, that was the appropriate forum for him to give evidence in relation to these matters. He has never suggested that he was withdrawing the serious accusations he made against the Chief Justice. One bears in mind in the letter that he wrote to the Deputy Director of Public Prosecutions on the 13th of February, he did point out that he himself, and perhaps your Lordship, my Lady should bear this in mind, had been acquitted by the self-same commission of any impropriety in relation to the land transaction, which is why Mr. Robertson's cross-examination, suggesting somehow he was unwilling to expose himself, is in our respectful submission somewhat bizarre. What my learned friend has emphasised in his recitation of the facts is that throughout this period, preceding the 5th of March, the Chief Magistrate's mind, as it were, his two stances were in tension. On the one hand, he provided statements which he knew was contemplated to be given for the purpose of criminal proceedings. At the same time, he was indicating a desire not to give evidence in relation to such matters. Equally, he was indicating at a stage late in February that he was prepared to attend, and yet again he retreated from that posture. The importance of that in our suggestion, respectful submission, is it makes it entirely credible that since his state of mind was ambivalent in that way, it would have been open to him, and indeed likely, that if persuaded that the reasons that he had put forward and openly put forward in the letter of the 13th of February, no doubt repeated thereafter, were bad reasons, that he would have performed his civic duty. Although my Lord Mant suggests that the press statement that he made on the 6th of March, in the immediate aftermath of the court hearing, was inconsistent, in our respectful submission, it was not inconsistent. He simply does not deal with that point at that juncture at all. One then comes to the question as to what the charge with which he is now faced, and whether it is contrary to the regulations and stroke or unfair for those to be pursued in the light of the allegation that he was originally asked to provide an explanation for. One bears in mind, one has to juxtapose the first allegation, which is at 1774, and the actual charge at 1822 in Volume 2. One bears in mind that they are discrepant in two ways. They are in two ways. First of all, because the refusal to be cross-examined has now departed the scene, and secondly, because the reference to in court has again been removed. And in our respectful submission, it would be quite wrong to interpret that as giving, as it were, latitude to include both what happened in court and what happened outside. In our submission, anyone receiving, as it were, the charge as presently brought would assume, as indeed the respondent's printed case makes clear, that actually they were pinning their colours to the mast of earlier conversations which took place with the prosecuting counsel on the morning of the 5th of March and before the parties ever came into court at midday. And one bears in mind in this context two factors. First of all, there's been no explanation, sensible explanation, given as to why the original allegation has mutated into the present charge, unless it was appreciated by the Commission that the original allegation could not be sustained. And in those circumstances, in our respectful submission, it clearly now is a different matter with which the Chief Magistrate is charged. And secondly, of course, the Regulation 90, subsection 6, obliges the Commission to leave the officer under no misapprehension as to the precise nature of the allegations on which the charge is based. My learned friend gives no emphasis at all to the epithet or adjective, that the nature of the allegations has to be precise. And in our respectful submission, again, the contrast between what was earlier alleged and the formulation of the present charge points only in one direction, that they have actually changed their position. And of course, in respect of that, the Chief Magistrate has been given no opportunity, as the regulations require, to make his answer. Now, my learned friend uses the phrase sufficient nexus. He wasn't the author of the phrase. I wasn't aware that he appeared before Mr. Justice Jammett. Indeed, the record suggests otherwise. He's entitled to borrow it. But it is, whether expressed by a judge or by an advocate, simply a forensic euphemism. There is nothing in the regulations that entitles one to say that as long as the offence with which someone is charged has some sufficient nexus with the original allegation, that it can then be brought. There's nothing in the regulations about a related allegation. It is all the allegation, such allegation, and the like. The connecting links between the two are links between something which was precise at the start, remains precise at the end, can be narrowed, but certainly cannot be expanded. And my learned friend says, but one can simply rely upon an explanation that has been given. I respectfully make two observations in relation to that. First of all, the explanation that can be relied upon must be an explanation to the allegation which one has been invited to explain, not something that by definition one has not been invited to explain. In fact, what is envisaged is that an explanation will be a defence to the original allegation. There is nothing in the regulations that suggests that it can itself be a ground for an amended charge. And one does bear in mind that under subsection 7, The admission that has to be made is an admission of guilt. It's not an admission of a particular act. It's accepting, A, I did something or omitted to do something, and B, in consequence, I accept that I was guilty of misconduct. So my learned friend gets, with my respectful submission, no purchase from subsection 7 of Regulation 90. May I go backwards, as it were, to Regulation 90, subsection 6. My learned friend says, one is entitled to charge an offence, and the indefinite article rather than the definite article is used. But one only has to pause for a moment to understand the verbal infelicity and lack of logic of that particular submission. Of course, the Commission at subsection 6 can't charge the offence because there is no offence that has previously been defined. The offence that has to be charged is the offence which is the subject of the allegation. And in our respectful submission, that explains why the indefinite rather than the definite article is used. And again, the balance of subparagraph 6 suggests that one may confine the earlier allegation, but certainly may not extend it or substitute a new allegation for the earlier.
Can I just ask one question?
Yes, indeed.
You focused on the words precise nature of the allegations.
Yes.
Am I right that there isn't actually a complaint made by your side that the present charge is insufficiently precise to be a proper basis for a charge?
No, the point I'm making is a slightly different one. What I am saying is that one can see, because one has to assume that it's compatible, it is a precise allegation, that points up the difference between that and the original allegation.
And insofar as it's precise,
exactly.
You would say it relates to the pre-court statements.
Yeah, exactly so. What we're saying is that it is quite clear, if they're following as best they can, but we say it sufficiently, the mandate of subsection Regulation 6, that they are indicating that they have changed their posture in the sense that they're no longer suggesting a direct refusal to be cross-examined, and they're no longer suggesting that what they're complaining about took place in court. And it's because one recognises that, the moment one says, this is precise, that one recognises it's not the same case that was being investigated by Mr. Justice Ventura. Two more points, very briefly then. Going backwards again, in subparagraph 5, and picking up the point that my learned friend adopted that fell from my Lord Justice Parker, on the particular act, in our respectful submission, again, the epithet particular makes clear that there is, as it were, a seamless sequence between the allegation, such allegation, the particular act, or it may be in plural acts, which would qualify as course of conduct, or no doubt there's an interpretation act which says an act includes an omission. But it's the word particular on which one must focus, because one's asking the Commission to adjudicate upon whether or not charges should be brought by reference to something that has been particularised. And finally, the argument based on 103 and 105, to the extent that there's a particular procedure for circumstances in which matters appear differently, I put it in the broadest way, to the tribunal than they did at the start. My learned friend says there's a striking absence of such a procedure in relation to the pre-hearing stage. Our submission, that is simply a non sequitur. One doesn't need such specific procedure because it's simply inherent in the language used in the pre-hearing stage, namely that the allegation has to be the same, subject only to de minimis, from first to last a charge, and the proper response to the decision taken, one assumes on legal advice, but it matters not whether that be so or no, was to, as it were, go back to square one if they wished to seek to do so, and ask the Chief Magistrate now to give any explanation he can to the present charge. In short, what we say is, of course we appreciate that it is convenient for the Commission, so much time having been spent on this already, and so much time having elapsed since these matters were first investigated, to say, let's get on with it and let's get involved in the merits. We say not only is that not just, because the Chief Magistrate's not been given the opportunity to make out his explanation the way that the regulations require, but actually in this case, it's not in accordance with the law either, because the regulations themselves are quite precise as to the nature of those rights. Unless I can assist the board further, those are my submissions in the text.
Thank you very much. The board is grateful to council for their submissions and will reserve its judgment.
We're very grateful to the board for sitting a little later. Well, you said there's no problem. I mean, I think there's one. I think there is one.
Come.